Hello, everyone, and welcome to another episode of the TCLF One-on-One Series. Through the One-on-One Series, we aim to interact with the best legal professionals from India and around the world. We are very honored to host Ms. Raveena Kumari Sethia Lalit with us today. Ma'am is currently a senior associate with the competition law team at Shardul Amarchand Mangaldas, which is one of the most prominent law firms in the country. She has earned a master's degree in law from the University of Cambridge, having graduated from Jindal Global Law School in 2017. She has also had the opportunity to complete a vacation scheme at HSF, which is one of the Magic Circle law firms based out of London. Ma'am, it's an honor to host you today.
Thank you. Thank you so much for having me. Really a pleasure to be here.
Right, ma'am. So, just a short message for our viewers. This conversation would be a more freewheeling conversation where we'll be talking to ma'am about her journey in the profession. What does an average day look like for her as a senior associate in the competition law team of SAM? How her different experiences have helped her in her career, and of course, the hotly debated and discussed Competition Amendment Bill 2022. So, just to get on to a first subtopic, ma'am, about your journey, it has been a very diverse journey, if I should say so. You've had the opportunity of studying in India and then completing a master's from one of the best universities in the world, that is Cambridge. So, how has the experience been like till now?
So to be honest, I didn't intend on becoming a lawyer when I was younger. I always wanted to be a journalist. But because, journalism wasn't something that was regarded as being very secure. In that sense, when I was in school, I decided that, maybe I should start out with law and then see where it takes me. So I was always planning to go to one of the CLAT colleges. I had gotten into DU for other courses like Stephens and LSR for other courses. So I was deliberating whether to do a 3 year later or do a 5 year straight away. And I was not, like going to Jindal was never on my mind. My grandmother actually saw a pamphlet and she said, just go and register and just give the exam. And I said, you know what, sure. And I remember very distinctly that the day that we had the exam, which is called LSAT for Jindal, we also had an exam for symbiosis in Pune. And I had, given the symbiosis exam properly. And then, I was taking this casually. I said, okay, whatever, let's go. I had never seen what the LSAT paper looks like also. I had no idea what they asked. And I get to the exam hall. It's literally like a multiple choice ABCD type of paper. I did it in like 45 minutes or so, as far as I remember. And like they have these slots, you have to like give it time. But like the quickest way, I was like, it's just something I need to tick from my list and I'll go home. And I did that, and I came back home, and then cut to a couple of months later, we were just deliberating options, and from the CLAT colleges, which were good, where I could get bumped up, etc. And suddenly we got the LSAT score for Jindal, and my score surprisingly was much better than what I expected, for the zero prep that I had done. And they eventually ended up offering me a 50% merit scholarship to get there. So it was actually my grandmother who said, you know what, I have a hunch, you go here, this will be a very, very good move for you. And I just went with her instinct. I told her I'll try it for 2 weeks. And if it doesn't work out, I'll come back. I'll join DU. I was also I'd also applied in the UK to King's College for a course called Politics, Philosophy and Law. So I said, if I don't like Jindal, I'll go to the UK. I'll do what I want to do there. And, I got to Jindal, and I don't know, it was just something about the place that, it instinctively I felt this is it for me, and I rescinded all my other offers, and there was no looking back. And today, when I see, I don't think I could have made a better choice. And these are things you only realize in hindsight. While we were there, we were always like, oh, it's so far, and this and that, what am I going to do socially? Where am I going to go? But today you realize the benefits of that environment. There was not a time when if I wanted a book, they would not get it. There wasn't a time where I needed a resource and they didn't provide it. And there wasn't a time where, I needed a permission, which was, over and above something to participate in an extracurricular, and they didn't grant it. So that way, they gave the opportunity and ability to so many of us to be able to try doing multiple things. And I think that is so important in student life, because you are just learning. It's too early to take a call on what you're good at, what you should specialize in, if I may so say. So I tried everything from mooting to researching to ADR to debating to writing to, you name it, and I've done it in law school. Anything that's possible to do, I have tried and done. And it was deliberate with the intention of seeing where does my strength lie and where does my weakness lie. It wasn't even with the intention of building a CV or trying to get a job or anything like that. And I think that experience and taking that all in really helped in terms of even deciding whether I wanted to study further or work, or what is it that I wanted. So that was pretty much law school for me. And once I was in my end of my third year, beginning of my fourth year, I got a pre-placement offer from a law firm in India called Trilegal. And I was very happy with that. I'd always done my internships with him and all of that. But when I was in my fifth year, I ended up seeing a lot of my batchmates and colleagues apply for masters. So I said, why not give it a shot? Let me see, and I'll do it for fun, and I'll apply and see where it takes me. So I just applied to two universities. That was about it. And I was, I got this letter that, I've been accepted in one of them. And the other one was like a wait list. I was going to hear back later. And I got the letter that I'm accepted. I said, okay, so what, I'm not going to go. I had made up my mind that I'm not going to put any more pressure on my family financially, and that now I was going to take it seriously. So I took a call. I was in the UK visiting my sister at the time. I booked a ticket last minute, and I said, you know what, I owe it to myself to at least give this interview. And I get there, and I saw other people there at this interview, and they were all older than me with work experience, more senior. I was the only one who was fresh out of law school at that point. And I thought, there's no way, that I'm going to get this. But it just so happened that it worked out. And it was 100% scholarship, including a maintenance grant, which was a monthly allowance for sustenance. And then I said, now, I mean, I have to go, right? Like, this is the universe sending me a signal. So that was pretty much how I decided to take up that call and go for my LLM without any sort of agenda in mind, but just that it worked out circumstantially for me. So that has been my law school and postgraduate journey.
Well, before I flag down to my next question, which is a follow-up to your answer. First of all, that was a very, very exhaustive answer. Thank you for explaining it so
I'm
well.
sorry,
Because
like my
no,
favorite rant.
no, in a good way, it was exhaustive, because it's kind of explanatory to our younger audience as well, who are right now in law school. And I completely agree with one thing, that it's very important to try out different things at law school. Not because it adds a certain value to your CV. I personally am of the belief that there are very few things which you can do in law school which truly add value to your CV. Other than that, everything is just for learning purposes and to see where your strength lies. So I completely agree with that. Now, you've mentioned how you got selected for a scholarship and then went on to Cambridge. A small follow-up to that question is, how was the experience different studying at Jindal and studying at Cambridge? From what I know, and of course, I've heard very good things about Jindal, the faculty, the resources. I've been there personally for a competition, and it's excellent. But of course, in terms of the academic pressure, as well as the kind of syllabus Cambridge offers, how was it different?
So I would say two things primarily. First is that Jindal is very based on the American University study model, which is that courses are broken up. There are internals, there are, then final exams, and classes are structured in a manner which is more interactive, where hypotheticals are asked, you are answering, it's always a back and forth. And this probably comes from most of the professors being young and coming from those law schools and replicating that model. Cambridge, on the other hand, is a very old institution and follows the British model, where most courses are lectures, where professors give, their lectures and you absorb that and take it in. There is a little bit of back and forth, but it isn't of the same level and nature. Because this is a postgraduate level course that I did, where people are expected to do reading and work on themselves after the lecture and deliberate and read, and then of course they're always welcome to approach their professors for doubts or questions or whatever it is. But the primary objective of the lecture is not to take you through the reading like how we do in India, or like deliberate and discuss while you learn, but the primary objective is that you've read and come and they are imparting their opinion and view on it, and you take that back and you think about it. So that's one difference. The second difference that I felt, I think, is that from an educational institutional standpoint, I think that because of being a younger institution, I think Jindal is like, there's always someone hustling to do something there. There's someone trying to do something new, there's somebody trying to come up with a new collaboration, or there is a there is scope for multidisciplinary opportunity, because there are so many schools and professors across the paradigm of academia. In Cambridge, while we had the same thing, it's a much larger, older university. The scope and opportunity for cross subject in engagement and interaction was slightly limited, in my view. In my year, maybe it changed and it was different otherwise, or maybe I was there for a very short time also, to be fair. But what I could engage in, which was not related to my subject or to law, was only limited things like the Cambridge Union, which is their debating sort of mecca, which is on campus, and certain other extracurricular things, like college forums, etc. But beyond that, I thought that there was so much more we could do in terms of increasing engagement, that I saw back home in our university, which I thought they could have done there also.
Right. That's another, very, very insightful answer. And I also think that Indian law schools, many of the law schools in India, of course, I won't name the ones that I know of who are following this practice. They don't have a very active, practice of giving these readings to students. They're constantly working on that traditional model wherein they're preparing students for the end semester exams or the mid semester exams. You just have to read certain portions and you're scoring a lot of marks and all that. But I think we need to get into that model wherein we are having constant, readings for students, because I think that the current generation of lawyers, including myself and my generation, of course, uh, we are not into that habit of, getting into longer texts, because everything has become so convenient with, these blogs, uh, and, smaller forms of writing as well. So that's a very important point. Now, ma'am, you've also had the opportunity of completing a vacation scheme at HSF. And I would just want you to share that experience as well. How was it like working with the Magic Circle law firm? What was the, work culture like? And what are the, since you're currently working with one of the best law firms in India as well, what are some of the distinctions that you have seen in terms of the working styles?
Yeah. So, well, HSF was an amazing experience. It isn't a Magic Circle law firm, but it's still very huge, reputed, and definitely multi-jurisdictional. And I think they, in my experience, that I was there for almost about a month, I think I saw that are students, so in vacation schemes, they don't just have students who are students of law, but there are people who have literally done like things like art or theater or things that are not remotely even associated with a law firm job, accounts, like multiple and diverse subject areas that they come from. And the idea through these vacation scheme programs is basically to see how does a person apply themselves to a given problem situation, fact situation, and how does that person work in a team environment. It is not to test how much law does that person know, because they realize that that is something that can be grasped with training and over time. And the scope is really to see how you are as a human being and how you fit in and how you think clearly. So even the selection for the vacation scheme, the whole process is structured exactly in that manner. So anybody, whether you're lawyer, non-lawyer, you can ace it depending on your nature and your thought process, really. And then the idea is that you come in, you work with two different teams over the course of your period, and you work with them, you sit in meetings with them, you see how their lives are, you try to do one project or presentation which is your own, and you sit and see how it would be to be in their shoes. And towards the end of the training, towards the end of the vacation scheme, they pick students and have training contract interviews for promising students. So that interview, in fact, once you've done the VAC scheme, that interview is much easier. And it gives you and them a better insight into whether you're a good fit. So for me, I mean, I thought it was a great place to work. I thought it was something that, where I was a great fit, and they valued my presence and eventually offered me a permanent contract and all of that. But I decided to come back and work here at that stage. But that would, if not, it would have been a perfect fit for me. And I realized that there were so many people there, some of them who didn't get that contract there, but they ended up getting contracts in other competing amazing law firms because they were probably better fits with their culture. And that was a great way, I thought, of selecting people to work with. Because at the end of the day, that's what matters, more than how smart you are or how much knowledge of something you have. It's how much you're willing to put in to collaboratively give a product. And that's how our law firm environments across the world are structured. And cut to India, and Sam, and I also worked at Trilegal before I did my LLM for a couple of months. So what I can say is that in our Indian system as well, there are some firms that do try to follow that model, where they try to see if someone is a good fit, to their work culture. But otherwise, we are essentially, our model of choosing according to the whole system is a little bit different from their model. And therefore, we learn a lot more on the job through trial and error in terms of, environment suiting us or not, which is a little bit different. But apart from that, I think culturally, any law firm across the world is fundamentally the same. The principles are the same. It is a question of putting in your time, teamwork, being able to balance tasks for each other, coming up with collective solution making, respecting a certain order and format of doing things, and delivering an excellent, impeccable, brief, concise, yet firm and caveated work product. So I don't think there's a great difference in terms of the actual work that you do day to day. It's just a little bit of a question of cultural difference. And coming to Sam, I think it's honestly one of the best places to be and work at, in terms of having a great focus on things that some other places do not do. So, for instance, there is support in terms of mental health. There is a lot of female representation. There is an active effort to create awareness on a lot of things, including certain socio-cultural factors as well, which you don't normally see in a firm culture. And I think apart from that, everything depends from team to team, and the culture of your team, and will determine how your day-to-day life sort of will go on. So that's pretty much the comparative between these.
And I agree to most of it. I think that most of the Indian law firms get need to get into the model wherein candidates are tested more on personality traits and upon the cultures they fit in, rather than a test of the legal acumen. You can always make a student make a better lawyer out of someone, but there's a saying, a quote going around a lot these days, and I think it makes a lot of sense that it doesn't matter how smart you are if I cannot trust you. And that's really, really important in a team, I think. And
Yeah.
the Indian law firm model needs to get into that as well. Now, talking about your work at SAM, how does an average what does an average workday look like? Of course, I know it's not static, I know it's not uniform, every day is different depending upon the urgency of matters, what kind of mandate you're handling. But
Yeah.
just to define it, what does an average day look like?
So I think an average day could involve you looking into, and I mean, let me first start with saying that what I do is an extremely specialized area of practice. But that doesn't mean that, we don't think about other things, or other things don't impact us as much. And I think it's a very wrong perception that people have, that if you work in a niche area or a regulatory area, you are restricted only to those questions. So, moving on from breaking, I think, that perception, or let's sort of keep that perception aside. We tend to engage on a daily basis with people across teams in our firm when they need advice for their clients on antitrust issues, when they need us to review their agreements and see if there's an antitrust concern. We have emails and advisory opinions being sought from clients across sectors on complex transactions or questions of law, where they haven't entered into an arrangement or agreement, and they want to check with us what the implications would be, how kosher would that be. And that even entails thinking from the client's perspective and coming up with actual, tangible, and practically implementable solutions for them. And I think that is a very, very crucial part of what we do, because that isn't really legal work, but it is thinking on your feet and being able to put yourself in someone else's position, understand their business, and take a call on, a recourse that could be convenient for them. Apart from that, we do a lot of work with respect to the CCI in terms of a client, if it's being investigated, then we help the client prepare, respond to notices received from the DG's office, prepare them for a hearing before the CCI, prepare them with respect to a merger notification filing. So we collate the information, we conduct a relevant market analysis, we undertake economic analysis as well, and we try to get their filings done and hope that approval is sought sooner, engage with the CCI to try to get them answers to questions, to ensure that the regulatory clock sort of is speeded up. And apart from that, we also do a lot of work which is more towards a litigation oriented side. So apart from CCI hearings, we also end up doing certain hearings which are before the NCLAT, which is our appellate authority, or the Supreme Court when matters go into appeal there. And those processes are exactly how any litigation team would have to handle them. So that you have to do briefings, you have to prepare submissions, you have to do the entire shebang that you would do if you were a litigating counsel. And so it gives you sort of a feat in both worlds, if you would ask me. You get to see corporate agreements, advise corporate teams on their side of things as well. Merger control is a little bit more corporate specific in that sense, when you're collating information and trying to put it across in a regulatory friendly format. And then you have all of these proper antitrust investigative issues, which are then going to the DG, CCI, NCLAT, and Supreme Court stage. So the day could entail looking into any of these questions. It could entail sitting and deliberating on things as a team and trying to discuss the course that we would adopt in terms of interpreting practices that the CCI has adopted, or just the letter of the law. We also have a lot of sessions where we do, trainings for each other on different topics and subjects. We do, active reading of new developments in the law, new cases, and there is a lot of academic oriented interaction as well. So the day is a mix of all of these multiple things in one.
Right, that was very insightful, and it will be very helpful for our audience who wish to go and practice within the competition law sphere at law firms. And a very important point that you've made is that once we join a particular team which is working in a niche or a specialized area, it doesn't mean that we are working in an echo chamber wherein other practice areas are not affecting us at all. And it's like a collaborative effort wherein teams are in constant interaction and working together most of the times, uh, or often, if not, uh, always. So that's a very, very important perspective. Now I'm just getting into the last sphere of our conversation, and which is about the hugely debated Competition Amendment Bill 2022. I remember while interning at a firm with the competition law team, there was a lot of talk about competition law amendments, and it was a scenario wherein it would be in the list of bills that would be tabled in the parliament, but it just never came up. And now it's finally picking up some pace. Uh, so, if you could just describe what are the some of the notable features of this amendment bill, and what are your views, and how do you think it would help or affect the present regime?
Yeah, I think so. The bill is a result of a lot of deliberation, discussion, and engagement among stakeholders, including representatives of almost every big law firm, representatives from the government, from think tanks, etc., where people came together for months on months and deliberated every nuance and change. So it is a result of extremely sophisticated efforts to bring about change and take into account that stakeholder consideration and feedback. So I think it's unlike a situation where there's something happening ad hoc. It is a situation where there's been a lot that's gone in. Not all of it has made it towards the end, but most of it has, which is positive. I think from my perspective, I think two key features I think will really bring about a huge change. Um, Three rather, I think. One definitely is that you have now a threshold which is going to be transaction specific. This could be because there are certain big tech transactions, especially where they acquire a smaller company and it sort of goes under the scanner because these companies have very low asset and turnover thresholds, and they often take exemptions of the minimum filing minimum, which is our target exemption thresholds, and they don't have to notify, and there's nothing illegal in it. It's just that's the law. But I think now, looking at the sophistication of these big tech transactions, looking at transactions that were just went by without any even regulatory intervention in that manner, the system is trying to be sophisticated and pick up on transactions now based on deal value, which may be a better threshold to assess how much is that company valued by a bigger acquirer, and then determine if it requires notification or not. And at least that gives you the opportunity to go into a more detailed review on those transactions. So I think that is one big change that's going to come about. Secondly, I think they have introduced a settlement provision, which I think will be a game changer. Currently, that's not something that you can do apart from maybe merger control, where you can offer some changes in how you want to sort of implement the transaction. But now settlements are going to be wider, most likely, and you can engage with the CCI actively to try to come to a solution, rather than it becoming a situation where you're always antagonistically fighting against each other. And I think that really plays to the spirit of the law, because at the end of the day, the idea of the Competition Act was to be regulatory and not to be adversarial. So it's not a situation where the company must keep defending itself to no end. It's a situation where now at least they will admit, much like the US and Europe and other countries, admit that there has been an issue and accept to do or make good to it or make amendments, and come with actual concrete solutions in real time, rather than waiting for years and years for the final outcome. And thirdly, I think, in my view, a key change is going to be, to reconsider merger notification requirements and filings from multiple perspectives. One such as exemptions for even on-market transactions, because it's so important for the regulator to step in the shoes of actual market players and participants and understand why are they entering into certain transactions, what is the timeline, is it something that they can help, do they are they trying to engage in gun jumping, or is it merely a question of timing and the way the transaction has been structured and the market is playing out. So I think these will really be game-changing decisions and changes. And of course, you also have, changes in terms of how confidentiality is going to be viewed and undertakings and all of that, which is already under, progress and being implemented. So there is a lot that's going to change. And I think it only seems welcoming. So, we'll just have to wait it out and see, and then we'll have to see how much more do we need the CCI and the regime to move further to sort of stay ahead of the curve, if not with it.
I absolutely agree with that, ma'am. These are certainly very, very important changes, specifically the deal value threshold introduction, as well as another feature that is the introduction or bringing within its ambit, within competition laws ambit, hub and spoke agreements. All of these, I think, are very important changes, the effects of which would be seen, of course, with the course of time. And with this, ma'am, we come to an end of our conversation. I've personally uh, enjoyed it a lot. It has been very enriching and insightful. Thank you very much once again. And if there are any concluding remarks for our audience or young viewers, happy to have that.
Thank you so much for having me. I think it's been a pleasure to be here. I hope some of this was at least helpful. If anyone has any questions on my journey or any way that I can help them, I'm reachable on LinkedIn, and please feel free to send me a message, and very happy to answer any follow-up questions. Thank you so much for having me.
Thank you, ma'am. Honor.